On January 1st, 2024, Mickey Mouse, in the form of Steamboat Willie, entered the public domain. The Walt Disney Company postponed this for as long as they could, but the time had finally come. This fact became the topic of many news stories. But how much does the general public really know about public domain and what it truly means? For me, there are a lot of questions to be answered. That's why I have Heidi Howard Tandy, a partner with the Berger Singerman law offices in Miami, Florida, visiting the show. Heidi not only has extensive knowledge about public domain, but is also a big Disney fan. For that reason, she's the perfect person to tackle this conversation. But before we jump into the conversation, I must say, all the information Heidi shares is not legal advice. If you're seeking legal advice, you must speak with your personal lawyer. I hope you enjoy my chat with Heidi about Disney and the public domain, and I'm sure you'll learn a bunch along the way.
It's time to dive into today's Disney dialogue.
Hello, Heidi, and welcome to Disney Coast to Coast. How's it going today?
Hi, I'm having a magical day at work.
Fantastic. Well, you are a type of guest I don't typically have on the show. You are not so much in the world of Disney, but more in the world of law, because today we're going to be talking about public domain. I feel like this is something, of course, Disney fans have been hearing a lot about this year because Steamboat Willie has become part of the public domain. But I do feel like, the general public tosses this term around, but I'm not sure we really understand what it means. So you're here to clear some of that up, yeah?
Yes. So for what it's worth, I am in the world of Disney. I really came to the issue of public domain when I was in law school. I started law school in 92, and I took my very first copyright law class in 93. A gentleman named Peter Yazzie, who is one of the geniuses in the field when it comes to fair use and transformative works. And he is not a copyright maximalist, but a lot of, copyright professors at other law schools are. So I learned from him a very different perspective, I think, than people at a lot of other schools might have learned. And one of the things I learned was something that everybody was being taught in 1993, which was in a couple of years, things were going to start hitting the public domain. I think at that point it was like 5 or 6 years away that things were going to start becoming part of the public domain because the copyright term was expiring on all of these works that were created in the 1920s. The last of the Sherlock Holmes stories, The Great Gatsby, things like that, some of the early Marx Brothers movies. And then I graduated law school. And then Sonny Bono died. And then they extended the copyright term in his memory. He had actually been very stalwart for the entertainment industry for all of his years in Congress to extend the copyright term and basically give a big benefit to large corporations, small writers, basically anybody who held copyright in something. And when he passed away by skiing into a tree, rest in peace, they extended the copyright term by 25 years. And there was no requirement to do anything. Everybody just got another 25 years. And for things that had been in distribution, for things that were accessible, you could still access it, but it meant that for things that were not necessarily accessible, like radio broadcasts from the 1920s and now the 1930s, frankly, the 1940s, all of those things would have been public domain. Wouldn't it have been really cool to have all of that available for podcasting purposes and just to listen to and all loaded onto YouTube for all this time? Wouldn't Google Books have been so much more fantastic if every magazine published in the 1920s and the 1930s was available? As it is now, politically, for example, all of the newspapers that were written in the 1930s as, during the Great Depression and as the world was marching its way towards war and fascism, all of that is still protected by copyright. You can access it under various fair use provisions for educational purposes, for research, for libraries, museums, teachers in classrooms. You can use it for all those purposes. But wouldn't it be great if they were just completely, absolutely accessible to everybody so that we would be able to see what happened back then? Unfortunately, the extension of the copyright term with absolutely no obligation to file or register or tell anybody that you owned the copyright in a thing and you wanted to extend it meant that all of these things became orphaned works. Obviously, not the things like Steamboat Willie that were owned by large corporations, but just random things that people might want to be able to access. All of it became protected by copyright until about 5 years ago when the copyright term ended and did not get extended again. So when something is in the public domain, we all have enjoyed things that are in the public domain, like Perrault's Cinderella, or grim fairy tales, including Snow White and Rose Red and Beauty and the Beast and Hans Christian Andersen's The Little Mermaid, and all of these different stories, everything obviously from Shakespeare, Hamlet, for example, which inspired The Lion King, some would say. Things that were written in the 1800s by Victor Hugo or Mark Twain stories, all of that was in the public domain by the time the Copyright Act got extended and remained in the public domain. You could change it, you could update it, you could turn Hamlet into, jungle creatures if you wanted to and put it on the African savanna. You could do so many things that were creative with things that were in the public domain. You could be Stephen Sondheim and Leonard Bernstein and take Romeo and Juliet and set it in Manhattan of the 1950s and turn it into West Side Story. But all of that was locked down for any content created after 1924, no matter what. And that is where we get into the issue of things that are now becoming part of the public domain and can be used by anybody for any follow-on work purpose when it comes to copyright, but not for trademarks.
All right, that was a ton of information. We're going to try and break this down and make it kind of layman terms. And let's just start very simply. What is public domain and why does it exist?
So the public domain is where anything that is not protected by copyright lives. Stuff is getting added to the public domain every day that is newly created. Do you know what those things are?
No.
Things that are created by the federal government cannot be protected by copyright. And that's why when Neil Armstrong landed on the moon in a government-funded project, every single thing he said there, every photo that's been taken by NASA, all of that has been in the public domain from the moment of fixation. It's not the moment of creation. It's the moment that something is fixed onto a hard drive, like this podcast that you and I are recording right now. The words that I'm saying in the ether here in my office are not protected by copyright. They're being protected by copyright when you are saving them on the computer hard drive in your office.
Fascinating. Okay, so the copyright issue is that these days, first of all, actually, it doesn't expire on exactly, what is it now, 95 years to the day. It's January 1st of the year, correct?
Correct.
So every January 1st, there's a whole new slew of things being added to the public domain.
Thousands of things, even though we're not necessarily aware of most of them. For example, every comic strip, every newspaper, every magazine, every catalog that was distributed in 1928 became part of the public domain on January 1st, 2024.
Okay, now why does this exist, though? Why shouldn't the creator of something own it for perpetuity and beyond them, their family and such? Why does public domain exist?
So when the French started creating copyright back in the 1600s, it was to protect the printer so that the printer would be able to make money back from what it is that he was selling, because he was selling the physical printed items. And at that point, the only things that existed were those that were fixed on paper or canvas or, I guess, stone and metal. But we didn't have the ability to create something that was audio at that point. That didn't exist until the 1800s. So there was basically, it was sort of a way of protecting like a guild, the same way that the guilds for wool had to have a specific stamp. And if you didn't have the ability to make this stamp, then you were not allowed to sell through your guild. So that same concept sort of expanded itself into the world of printers once printing became something that was being done commercially. Before that, books were mostly created by monasteries, and you had to be very, very wealthy in order to afford something that was, handwritten. And then, of course, we're talking mostly about Western Europe here. Obviously, in China and Japan, throughout India, Northern Africa, etc., there was a extensive creation of wood blocks. And this was, of course, happening, across Europe as well, where something would be carved into wood and you could make multiple prints of it until you wore down the wood so much that you couldn't anymore. It was with the invention of movable type that printers' guilds changed, and you could create things more rapidly and you could create things more inexpensively. So copyright became a way for the person who was printing the thing, Shakespeare's first folio, to make money on what it was. And they would purchase the rights to the thing from the author. So the author wasn't like getting royalties the way that they do now. As a general rule, there were, of course, writers who were also printers, and we can look at Benjamin Franklin for something like that. But by having somebody who was a writer and a printer as part of the creation of the Constitution for the United States, that's how copyright got, and to some extent patent, got itself created as something that is federal law here in the United States. Copyrights and patents, although not trademarks, are in the Constitution. There is a term for copyright, and I mean a term in terms of the number of years, for copyright in the Constitution. I think it was originally 14 years, and then you could renew it for another 14 years. And it created a federal office and everything for it. James Madison wrote the Federalist paper on it. It's about 300 words, one of the shortest ones, because there didn't seem to be too much to say about it. It was for the creation of arts and sciences. The person who has created and printed the thing gets to own the thing for a limited number of years, and nobody else is allowed to copy it. And because the current Copyright Act still has a limited number of years, 95, for something that is owned by a corporate entity, that's still considered limited as a matter of copyright law. When the Copyright Act extended the term for copyright back in the late 90s, there were lawsuits about this that went all the way to the Supreme Court, and the Supreme Court said, well, no, 95 years, that's still limited. But it made people feel that if it got extended anymore, the Copyright Office might not, the Supreme Court might actually say, no, that's not limited anymore. That feels relatively unlimited. We're not going to let you extend it again. But literally until January 1st, midnight, and 1 second later, I was standing at Epcot in the middle of World Showcase, and I was like, they didn't extend it. It didn't happen. It's in the public domain. And it was just, I felt it in my soul. I had been waiting for this for so long.
So you were actually expecting Disney to get it extended again at that short notice. We're talking about Steamboat Willie here.
I didn't think there was any rational way that they could do it. Joe Biden, was on vacation. He would have had to sign it. And there was no way, from the minute that Ron DeSantis had his fight with Disney, there was no way that there was going to be some sort of groundswell of support on the Republican side. And of course, it's a Republican-controlled House for Disney to be able to keep Mickey Mouse out of the public domain. Or not Mickey Mouse, Steamboat Willie.
So I don't know if we can touch on this. Let me know if this is a problem. But I'd love to get personal opinion here, because I honestly am very torn. Once again, why shouldn't the creator own it for perpetuity?
Because the Constitution says that it is a limited right.
So it's just because a rule was made.
You would literally have to amend the Constitution in order to make it an unlimited right.
I don't know if that's obviously it's the Constitution. I'm just trying to think morally for myself. I'm like, is that a good reason? Just because It said so, it's a law, essentially. I don't know. I'm trying to, like, what's the benefit of it to
Well, the
expire?
benefit of something becoming part of the public domain is we get West Side Story out of Romeo and Juliet.
Oh, sure. Trust me, I take advantage of public domain. I love as a theater fan, I love how many different interpretations of things we can get. Like, I love the result of it.
If it's owned by an individual, it's not a 95-year term. It's when you die plus another, I think, 75 years. So you and your children and probably your grandchildren are going to be able to get some sort of a benefit from that copyright. You'll have the exclusive right to sell, to use, to make copies of, to create derivative works from.
And what year did that start? Like, was Charles Dickens involved with any of this, or he was always kind of public domain?
Well, no, I mean, he was born after this.
He was born after it. Okay, so he was protected.
When public domain started, it was 14 years, and you could renew it for 14 years.
Wow.
And
okay.
then in the mid 1800s, it got extended, and then in the early 1900s, I think 1907, it got extended again, and then there were additional extensions. Then there was another one in the 70s. So there were all of the. It didn't suddenly go from 14 years plus 14 years to 95 years in a blip. It happened gradually. And every time there was a change in technology, there was a debate as to whether will this new technology be protected by copyright, like photographs, because when you're taking a picture, especially if you're taking a picture of a real actual thing that is happening, how much copyright ownership should you get in the thing that you were photographing? And this was like, so last year, I don't know if you are familiar with the Andy Warhol case that went up before the Supreme Court.
No.
So back in the late 70s or the early 80s, a woman whose last name is Goldsmith took a photo of Prince, like right when he was starting to get big. And she says that she has extensive copyright protection in it because she was the one who decided where the lights would be so that they would light his eyes with a pinpoint of light specifically. And she's the one who had him hold his head in a certain way. And therefore, she deserves all the copyright in this thing. And when Andy Warhol was asked to create a work based on it. So this was in the 80s. This was before fair use existed in the form that we know it today. And I don't want to go all the way down that track. But Condé Nast got a license for Andy Warhol to use her photo as a reference in creating some art. Warhol created, I think, 35 different pieces, all inspired by this photograph of Prince. And when Prince died, I think it was, again, Vanity Fair got a license from the Warhol estate to use one of those images on a magazine cover, but they didn't go back and get a license to it from Ms. Goldsmith. So she sued for copyright infringement and said that he was infringing on her work. My big question in this has always been, how much protection should she have had for Prince's face? And this sort of dovetails into Disney in a way because it's pretty clear that their contractual agreements with their live action actors in recent years has included ownership of the way that person looked in a specific film. We can look at Enchanted or something like that, or the way that Disney has, done the live action versions or the CGI action versions of various other movies through recent years. People assume that that's so that they can extend their copyright protection in those stories, but doing that doesn't extend the copyright protection from the original source work. So right now, I think we're 7 or 8 years away from Snow White becoming public domain. But of course, in a year or two, we're going to get a live action Snow White movie. Will that minimize the risk of people creating their own live action Snow White movies that are shot by shot versions of the original Disney version? Possibly, because by doing so, they might be infringing on the images and the visuals in this newly created version by Disney. But it won't extend Disney's copyright in, for example, the song I'm Wishing, just because they use it again in this new film. Similarly, I think we're 8 years away from Superman becoming public domain. Yes, people are going to start making their own live action versions of Superman, but they cannot mimic anything shown in any of the films or the TV series or the cartoons where Superman has been used in other media, because those were all later created. So the protection for the character will end. The protection for later versions of the character, the same way that Fantasia Mickey is still protected by copyright, that will remain until the secondary work goes into the public domain. I mean, part of the reason is just really Ben Franklin wanted it to be that way. And Thomas Jefferson and the other people who, well, not Jefferson, he was in France, but the other people who were involved in creating the Constitution, a number of whom were writers, a number of whom published things that were not protected by copyright at the time they were created because they were published anonymously. So I just want to touch on this very briefly. Until the 1970s, so really only the last not quite 50 years, you couldn't get copyright protection for something that did not have a copyright notice on it. So photographs, books, phono records, if there was a copyright notice on either the label of the phonograph or on the sleeve itself. Movies would have, that little copyright notice in the beginning and the end back in the olden days, in order to make sure that the protection remained, in the work, especially because initially it wasn't clear whether you would have to have copyright notices in the beginning of something or the beginning and end of something, just because there wasn't statutory language legislation on that particular issue. So for a very long time, if you created something and put it out in the world like a letter, there was no copyright protection for that. However, last 50 years or so, things have been protected by copyright, even if you don't have a copyright notice on it. And that's why all of your email is protected by copyright. Every single email that you've written is either protected by copyright by you or the corporate entity or NGO that you've written it for, unless you are writing emails on behalf of the federal government, in which case they're not.
Wow. So this is so fascinating because there seems to be a lot of rules that are, laid out. So it seems like one of those things that if a case is taken to a courtroom, it's like, nope, it's very black and white. These are the rules. But at the same time, it sounds like it can get tremendously complicated.
It's gotten a lot more complicated, and I'm not going to go down this road terribly far, but there's also things called statute of limitations, which is a limited period of time through which you can sue for copyright infringement. That time frame is 3 years. However, there's two different ways you can recover if somebody infringes on your copyright. There's statutory damages and there's actual damages. So you cannot get actual damages going back more than 3 years. However, if somebody infringed on your thing more than 3 years ago and it's still up, it is a mixed issue right now, depending on what circuit you're in, as to whether or not you're going to be able to get damages in connection with that infringement that are statutory damages, because the infringement is happening within the statute of limitations, but it began before the statute of limitations. And I'm not even talking about copyright management information. And if you remove it, then there are penalties for that separate and apart from everything else, even if a work isn't registered.
And everything we're talking about right now, this is all nationwide, right? These aren't state-by-state rules.
No. So there's a concept called preemption, which is basically if there's a federal law, the states can't legislate on it. Copyright and patent are two of those things. Trademark is not.
So trademark seems to be like the superpower.
Yes. So trademark can be perpetual as long as you are either using the mark or you've paused using it for a brief period of time with the intention of resuming use of it again. So that's why, for example, you'll see a lot of, how everybody had local stores growing up that are now all Macy's. You had a Bullock's or a not JCPenney's, Jordan Marsh or Burdines or whatever, Marshall's, and they're all Macy's now. But Macy's makes tote bags with those other brand names on it so that they're continuing to make use of those marks, which prevents any, random Florida clothing store from calling itself Jordan Marsh or Burdines. And that's actually trademark is the way that Disney has given themselves an extended lease on life for protection of the Mickey Mouse at the boat wheel element of Steamboat Willie.
Okay, so but they couldn't have like trademarked the entire short film. No, just
No.
an image.
I mean, they could probably trademark other additional parts from it, like Pete or, some element of Minnie if they wanted to. And they probably they may have, trademark registrations for those. But it wouldn't be for every single element shown within the film, the same way that all of Mickey Mouse in that film is not protected by trademark, just at the wheel.
At the wheel. All right. Fascinating. Yeah. So there's a lot of terms that I feel like kind of get thrown in together and maybe mistaken for one another. We've been talking about public domain, but there's also Creative Commons and royalty free. I feel like these are terms that people kind of confuse. Can you touch on them?
So Creative Commons is a nonprofit, and they created a license system over 20 years ago, maybe 25 years ago, that if you use their licensing scheme, anybody can use your work as long as they are in compliance with the license. And there are good and bad things about this. Number one, it's a way to say, for example, if you have photographs and you want people to be able to use them, or if you have, little blips of music and you want, or longer songs and you want people to just share and enjoy, then you can do that by putting a Creative Commons license on it. Some people who write fanfic, especially fanfic for things that are in the public domain where nobody is making a copyright claim about it, some of those people will also, and for fan art, put Creative Commons licenses on their things. However, there is one thing to be very careful about for Creative Commons, and that is because it has been weaponized by copyright trolls. For example, there are companies that have created, using AI, a word on Scrabble tiles sitting on, one of those little Scrabble holders, or a word coming out of a typewriter, or a word handwritten on a clipboard. And people used to more use these on blog posts because you would Google the word X on art, and all of these things would show up. And if you took the image directly out of Google without going to the page itself, you wouldn't see the full Creative Commons license information. You would just see, Creative Commons licensed showing up in the Google search. Now, not a lot of, but there were a number of copyright trolls who weaponized this and put tags in their things so that they could find it. If you took one of these images and put it on your website and didn't include the extensive or even limited credit that was required pursuant to the license, or if you were using it on a web page that they deemed commercial, even if that commerciality was your blog about being a private school teacher, or something where you were doing a GoFundMe, then they would say that you were infringing on their copyright and you owed them $250,000, but they'd be happy to settle for 3, 5, 7, 12, whatever. And this was terrifying to people because, they would say, and, counterfeiting can incur criminal penalties. I've seen these letters. They're horrible. And it, made it very, very confusing and confounding for people who thought, oh, I'm getting this image by Creative Commons, I can use it, without knowing what all of the parameters required were. And of course, if they tried to sue you in court and you defended yourself, then you wouldn't owe $250,000 and the FBI was not coming to arrest you. But a lot of people didn't know that. And this was happening, for a while before copyright attorneys became aware of it. We started posting blogs saying, here's what you do if you get one of these letters. So Creative Commons is great if you're really informed about what the parameters are and you're making sure that what you're using is actually created by somebody who is not doing it to try and scam you or terrify you.
All right. Well, I'm staying away from Creative Commons. You just scared the crap out of me.
I mean, you don't have to, because now you're aware and you know what to do to make sure that you're not going to have a problem. Royalty free is the same kind of thing. If somebody says, oh, you can use this image royalty free if you do X, Y, and Z and also stand on your head, that's great. But there's an argument to be made that asking for all of those terms and conditions and requirements is actually a de facto royalty. And again, there isn't really that much case law about this because everybody settles. Mm-hmm. Case law is, when two people debate something before a judge or before a jury, and then the judge issues a ruling, and that ruling is what's called case law. And it's also called common law. And that's really how most of the law is built up in the United States. The statute is all well and good, but it's the interpretation of it that governs how people use it in the real world.
Alrighty. Now, you've touched on this a little bit already, but I want to get into, of course, listen, Disney is not happy, I'm sure, about this whole Steamboat Willie situation, but the company sure used public domain to their advantage and still uses it to their advantage. And this goes all the way back to Walt Disney himself. Snow White and the Seven Dwarfs, of course, was a 1937 film based on public domain. Pinocchio, 1940, same situation. Cinderella, 1950, same situation. Sleeping Beauty, 1959, same situation.
Sleeping Beauty also used public domain music.
That's right, as with those Sleeping Beauty waltz. That's right. Mm-hmm. Wow, okay. And then after Walt, even many years after Walt, The Little Mermaid, as you mentioned, in 1989, Beauty and the Beast in 1991, and so on and so forth. So, as much as I'm sure the corporation wants to kind of fight this to continue owning their works, they have to recognize we've been doing this for years. It's been advantageous for them.
It is. It is. And, without having a robust public domain, we wouldn't have had all of these stories. I mean, Pinocchio, I actually think, was barely in the public domain when the Disney film was made. The Wizard of Oz, if the copyright term had existed when Baum wrote the original stories, we wouldn't have been able to have The Wizard of Oz. We might have had Wicked. It would have rolled over, but we wouldn't have had all of these absolutely fantastic experiences that we got to enjoy because things would have still been protected by copyright. I think the Perrault version of Cinderella was written in the 1860s, maybe even the 1870s. So again, if the copyright term was 95 years for that, we wouldn't have had Cinderella as early as we did.
Wow. You mentioned Wicked, and this goes back, this just reminds me of something. Many years ago when I was in college, I interviewed Gregory Maguire, the author of the book Wicked, and he told me a story where he's like, I just wrote this story because I had an idea. And he's like, and right around the time that, I was sending it to publishers and stuff, The Wizard of Oz had become public domain. I don't know if he was talking, no, not the film, but something had become public domain that allowed his work to be more easily published. And the publishers were like, oh my gosh, this is you're so smart. This is perfect timing. It's I had no idea. I just had an idea and I wrote it.
I think it was the last of the Oz stories became public domain at that point, which is the same kind of thing that we have for Sherlock Holmes, because the first Sherlock Holmes stories were in the public domain, technically, possibly before the Copyright Act extensions manifested in the 70s, but the Holmes estate has been so litigious about this. And it really wasn't until I think 10 or 11 years ago that a court in Chicago basically shut them down and said, no, these are all in the public domain except for the last 4 stories. So people can't copy those last 4 stories, and a characteristic that only manifests in those last 4 stories is still protected by copyright. Everything else is in the public domain, and you, Holmes Estate, for continuing to assert copyright that you should have known you didn't have, now have to pay the legal fees for the people who sued you for a declaratory judgment, which is a declaratory judgment is when somebody asks the court to declare that a thing is legal or illegal.
Wow. Okay. So we touched a little bit earlier on the Sonny Bono Act of 1998, I believe. And as 2003 approached, Disney continued lobbying Congress, resulting in increased terms of corporate copyrights from 75 to 95 years. And this, I know Disney gets a lot of attention for it because they're one of the biggest corporations, but there were, several entertainment companies involved with this.
Yes.
Can we talk about that a little bit? How does Disney even fight that and prove that it's worthy of happening? You know what I mean?
So they just lobbied for it. And at the time, I probably would have been okay with the idea of those who want to continue their copyright protection, you can have it, but you should have to pay the federal government $1,000, $5,000, $10,000, something. You should have had to pay something to get that. Sorry, I get heated up about this. You should have had to pay something to get that extension of copyright at that point, because by imposing it on everything, that's what extended the copyright for every newspaper article, every magazine article, every radio play. And unfortunately, not so much for the stuff on paper, but for the stuff that's recorded, a lot of stuff has deteriorated a lot in these ensuing 15 years. And that's not great because, yes, Google and museums and libraries made copies of as many things as they could because they were allowed to because of an exception to the Digital Millennium Copyright Act. However, they couldn't catch everything. And there's stuff that we don't have in the same quality because the copyright terms got extended. And yes, maybe there would have been people who wanted to archive those things and distribute them on DVDs in 2004 and 2005 that didn't get to do so. Remember, we didn't have YouTube for another 5 years.
I mean, obviously, Disney and the other entertainment companies were successful from going from 75 to 95 years, which is a pretty good chunk of time, another 20 years. What stopped them from doing it again? Like, did they even attempt to extend it again?
They didn't really. And I think some of it was the Supreme Court saying 95 years is limited. We're not quite sure that 96 years is limited. We're really not sure that 100 years is limited. So because the Constitution says that copyright is a limited term right, the minute it becomes unlimited, it's unconstitutional.
That's just so fast. I'm curious, like, why 95, right? Like, why not 90? Why not 100? You know, obviously somebody...
Why not 99? It's easier to calculate.
Yeah, it's, I don't know, it's just so fascinating that 95 is, somebody decided that's it. That's the limit of limit. You know?
And the industry may have thought, okay, let's do it for 20 years. And then in 15 years, we'll start pushing for it again. And they didn't know that an entire field and educational perspective would come up around the idea that things should eventually go into the public domain and that creativity would be so, I don't love using the word democratized for this because it's always been democratized. I mean, how many people, spent their childhoods doing plays in their parents' room or in the backyard? And, if it was recorded on somebody's handheld video camera, then it was being fixed and it was infringing on somebody's copyright. Oh no. But we didn't have a distribution method for it. So nobody really worried about it or cared. But obviously the last 15 years have seen distribution methods expanded in ways that were unpredictable. But it's also caused an expansion of the concept of fair use, which I touched on earlier. And arguments have been made that things that utilize, whether it's viral, whether it's commercial content, whether it's, films and music and movies that get into a discussion of it or an analysis of it, or, the modern version of pop-up videos where little factoids are coming up about the thing that you're watching, or reaction videos or unboxing videos, all of those draw on and utilize works that are protected by copyright. Obviously not all the time. I mean, there are reaction videos to things that are in the public domain and have been for a long time. But there is an element of copyright follow-on works in that kind of creativity that is, all over YouTube, all over TikTok, every other kind of, audio-visual media. And having that as something that people can utilize with regard to fair use, I think may have made the powers that be, which is another word for the major multinationals, feel that if they tried to extend the copyright term again, there would have had to have been an expansion of fair use alongside it.
Now, we've been talking a lot about Steamboat Willie, but we can't forget that in 2023, so January of 2023, Disney also not lost the rights, but Oswald the Lucky Rabbit went into the public domain. And kind of a result we're seeing with that is, I don't know if you've seen the trailer yet, but Oswald Down the Rabbit Hole is a horror movie version of Oswald, very similar to Winnie the Pooh Blood and Honey, which came out, was that a year or two ago, which, not owned by Disney. It was a Milne
version. Yeah.
Yeah. I mean, this is the thing. People are making horror versions of wholesome things definitely seems to be a trend when it comes to public domain.
The thing is, you might have been able to do those kinds of horror things, especially distributed through indie distribution channels, even when things were still protected by copyright, because there's an argument to be made that that kind of content is parodic. In other words, it's a parody. There is, I'm going to use the word explicit here on purpose, there is explicit case law that says that creating something pornographic that is inspired by copyright protected, more characters than the actual visuals, is a parody of the source material. And parody is one of those fair use things that is not copyright infringement. Obviously, for example, Saturday Night Live, Mad TV, and Living Color, all of those engage in parody and are allowed to do that to things that are protected by copyright, not in the public domain. But the explicit case law that says that things that are turned into porn when they are normally wholesome is a parody. So those kinds of arguments can be stretched to horror kinds of situations. It doesn't work the opposite way, though, because when Will Smith and DJ Jazzy Jeff tried to do a parody of Nightmare on Elm Street called Nightmare on My Street and did a song and did a video, that was considered copyright infringement, also trademark infringement of the Nightmare on Elm Street franchise. And they had to pull it for a number of years. I think eventually they managed to work something out, but the video was pulled from MTV and not allowed to be played on the radio because, was it New Line, felt that it was infringing on their copyright because it was basically telling a version of the Freddy story from, the Will Smith perspective. And you can find it on YouTube, but those kinds of things were not considered parody, taking something horror and turning it into something funny, but the other way around would count. However, taking something that is already pornographic and making it pornographic is a copyright infringement, at least according to the Central District of California, when there was a litigation before them with regard to 50 Shades of Grey, and that's all I'll say.
Wow. Okay. I love how there's often a however attached to all of these statements. But you mentioned Saturday Night Live, and I've actually always been a little curious about this. So SNL is obviously all parody sketches and such, but correct me if I'm wrong, I would assume most companies like The Gap or whomever trademark their logos, correct?
Yes.
I'll often see, like in a Weekend Update segment of, news parody, they'll use like a store logo or something. How are they getting away with that? Even though it's parody, they're using a trademarked logo. How is that allowed? You know
how I mentioned earlier that there's fair use of copyright?
Yes.
There is also fair use of trademark. It is a different principle. There is different case law. You can't use the case law from one on the other. However, fair use of fair use of trademark is allowed, again, if you are parodying something or if you're actually talking about the thing. That's why no stores need to get permission from Coca-Cola to say, we sell Coca-Cola. However, if you go to a restaurant, fast food, whatever, a restaurant that has fountain service, and you order a Coke and they don't sell Coke, and they don't say, we don't have Coca-Cola, we only sell Pepsi, and they bring you something, and a tester from Coca-Cola is there that particular day, they're going to get hit with a trademark infringement suit. Happened much more in the 70s and 80s, much less now, but you can't pass off Pepsi as Coke.
Interesting. So, Steamboat Willie is kind of the newest big thing when it comes to Disney. But one of the things I found kind of interesting, we were just talking about how Oswald has become a horror movie. One of the things I found interesting with Steamboat Willie is I don't find people necessarily creating things with it, more kind of just mocking the fact that, hey, we can now play with this if we want to. People like, John Oliver have gone on huge tangents about this. And that's just been kind of fascinating. To be fair, it's been less than a couple months since it's become public domain. But at the same time, people knew this was coming. This was something many people were paying attention to. So let's face it, on January 1st, 2024, there could have been a Steamboat Willie horror movie released, correct?
Yes, there could. Although Steamboat Willie already has some horror components in it, so maybe people felt you didn't really need to do that.
But it is interesting to me that so many people seem to be celebrating the fact that Disney has lost some control. It's kind of fascinating to me.
It really is, and it's been fun seeing what people like John Oliver have done with it. I have a t-shirt that a friend designed for me that has, Mickey, Steamboat Willie Mickey, wearing a Sherlock cap, one of those deer stalkers. And there's a ribbon all around it saying my fandom is in the public domain. And I have it, printed for me to wear when I go to Magic Kingdom, which is nice. And when I was at Disney World on January 1st, those little pins that they will write things on, I asked very nicely, and they wrote on it, I'm celebrating, and I asked them, and they did it, the public domain. So I now have a little pin that says I am celebrating the public domain, and I wore it all around the park for 2 days. And a couple cast members asked me about it, a couple people in line. I was like, yes, Steamboat Willie is in the public domain. And some of them were like, oh, I heard that. I won't say which cast members, don't want to get anyone in trouble.
So you're very excited by that. Like, why does it, wow, you're really excited. Explain to me why it excites you so much.
Because it means that people are able to get creative with things that they haven't been able to play with forever. I mean, they've never been able to play with these kinds of images and these kinds of stories. And by releasing things into the world of where people can, play with them, it gives a lot more opportunities for people to do something that might give somebody, 15, 20 minutes or 3 hours of enjoyment. I see behind you, you've got a Frankenstein poster. There have been how many millions of different iterations of Frankenstein, and the elements of it show up in other things. Like if you look at, just Sally in Nightmare Before Christmas, would that character have existed in the form, using form on purpose, she did if we hadn't had Mary Shelley's Frankenstein in the first place? I don't know. So having all of these creative things released into the great wide world gives us opportunities to see where people will take them. Like, say, for example, Victor Hugo's Les Miserables. Obviously, movies and plays and things like that all the way through the, teens and 20s and 30s and 40s. And then in the 80s, we had the huge musical, which then got turned into the huge musical movie. But all along, people have been writing novels from the other characters' perspectives. Those are stories that, people are able to read, and see what direction it goes in. There's millions of different versions of every single fairy tale that you can imagine. And then, of course, Disney has done their own versions, alternate universes of the fairy tales that they themselves have made. What if Elsa and Anna didn't grow up as sisters? All these different storylines that, things can go into different directions. Marvel has made a huge continuity offshoot by having 3 different versions. I mean, they had What If comics going back to maybe the 50s, definitely the 60s. Then, of course, we had the entire Loki series. And then, of course, there's the Marvel's What If series on television. And it goes into so many different perspectives. There's a multiverse out there of stories. So what's Steamboat Willie doing in the multiverse? Like, where can people take him in these different directions? And maybe as more cartoons that we're familiar with become public domain, and maybe as more and more things become accessible, we'll have more different kinds of crossovers and more, different kinds of experiences and stories out of things. So, I'm expecting that we're going to get to see some, interesting perspectives and content coming in all sorts of different ways. And at the very least, it means that if people are doing something academic or something educational or something informational, they can now use all of this content without having to worry, oh, is Disney going to have, give me a strike from my YouTube channel and have it taken down?
Well, what's interesting is Steamboat Willie, although we all recognize him as Mickey Mouse, is definitely like a very specific look. He's black and white. He's got the solid eyes and stuff. What's going to be really interesting, and I know we're many years away from this, but when the different versions of Mickey start becoming public domain, that really is just a lot closer to what whatever current day Mickey is at the time. It'll be interesting to see, does Disney decide to kind of give Mickey a drastically different look so that what people can do with public domain when those things become public domain won't be mistaken for official Mickey? It'll be interesting.
It'll be very interesting. And I think when Fantasia becomes public domain, it's going to be a much bigger issue.
Is there an official source?
So Duke University has put together a fantastic resource, but it's part of Duke University's law school website, and it showcases what is becoming public domain each year going forward. And that's why my husband and I are now counting down to Superman.
So are there any limitations at all when it comes to Disney and Steamboat Willie, or no?
Yes. You can use every single image. You can take Steamboat Willie, and what nobody's done so far, and I really want somebody to, maybe I'll just eventually do it, is every single frame from that movie and turn it into a flip book. And you can just flip through it, and you can carry it yes, we have our phones, but you can carry it in analog form wherever you are, and it can't get deleted, and you have a flip book of Steamboat Willie. You can put it in the corner of another book. You can do that now. If you're doing, a Disney guidebook that's printed out on paper, you can have little Steamboat Willie in every single corner, and you flip through it and he's, walking around the page. I love that. I mean, isn't that adorable? Why hasn't anyone done this? So so you've got things like that, but you cannot take the, Mickey at the wheel Steamboat Willie and put it on the front of another movie or film company or TV company's products and have that in the front there, because that looks like the Disney trademark, and it will cause likelihood of confusion for people to think that your film is somehow affiliated with or distributed by Disney. If they're not willing to say it for Midnight Madness, then you shouldn't be saying it for your own kind of product.
Now, was there anything, I'm sure if there was something, Disney would have done it, but let's just hypothetically say Disney had said, hey, we're going to remake Steamboat Willie. This time it's going to be fully CG, but it's literally frame for frame, the exact same film, all CG. Would that protect the character? I guess it would not protect the hand-drawn version, but it would protect a CG version, or no?
If it's identical, then it wouldn't give any additional protection. If it had color in it, if it was 8-bit, then it would give protection to that overlay, but not to the original source material. You can't extend copyright by doing something new with the copyright protected material.
Can places have copyright? Is Disneyland a copyrighted place?
This is interesting. Until the last 30 years or so, you couldn't get protection for boat hulls or architectural drawings. Now you can. So there is copyright protection in every single new building that Disney has built. You can't recreate that. Even before that, things, especially the contemporary, is used as a trademark. So you can't copy the way the contemporary looks and use it somewhere else. But does that mean that you can't, create a building that looks extremely similar to, I don't know, And then there's, stuff that Disney does that's relatively off the shelf, like the Zephyr ride out at California Adventure. So there's different things that Disney has done that are not necessarily protected by copyright or by trademark for Disney exclusively. But that doesn't mean that Disney doesn't hold some copyright and some trademark to those things, especially the ones that have been recently created.
Wow. Okay. Now, I do feel like obviously there's always people breaking copyright laws. And one that pops to my mind is tattoo artists. How many people have we seen walking around with Mickey Mouse tattooed on their body? Like, who can get in trouble for that? The person that is wearing Mickey on their body or the artist that tattooed that body?
So tattoo law, I'm going to use
There's
this
a
word again
tattoo
on
law?
purpose.
Oh my goodness.
No,
Okay.
there is not a specific tattoo law, but a body of common law has been created about tattoo law, including the face tattoo that Mike Tyson has and things like that. Generally, the artist holds copyright in what it is that they are creating. But if they're utilizing somebody else's creation, then they don't get protection for what the source material included. However, remember how I said fair use can give pretty broad protection for people doing things individually? So for the same reason that somebody is able to, draw something for themselves or, turn it in school or something like that, that's all protected by fair use. Tattoos of things that are protected by copyright are in a slightly different perspective. So there's two different things about this. Number one is short phrases and titles cannot be protected by copyright. So having, 4 or 5 words from your favorite movie or your favorite musical does not violate anybody's copyright. We don't talk about Bruno, 5 words, not protected by copyright, too short a phrase. Also, not the heart of the source work. In other words, a poem that's only got 30 words, you copy 5 words from it, you might be infringing on the copyright. But 5 words from a song generally is not considered copyright infringement when it's used in a non-song context. So for something like that, it would be considered too de minimis or the source work is unprotectable. But you're only infringing on somebody's copyright if what you're creating is substantially similar to the source work. So if somebody is just having, the Sorcerer Mickey from Fantasia tattooed on, their arm or on their leg, then that actually might be a copyright infringement of that particular movie poster iteration of Mickey. So there are some tattoo artists that will not do that sort of thing. But they'll create their own interpretation that is more amorphous and more artistic. Utilizing source material to create something artistic is something that falls into the bounds of fair use. So if you're not making an exact copy and it's not substantially similar to the source material as a whole, then arguably it's not copyright infringement. But I say arguably because going to court for that kind of thing can take a lot of time and effort. You don't necessarily want to put your life on hold for a couple of years and have to go through all of your old emails and text messages in document production.
Wow. The type of work that you do, are you typically working for like a corporation or for individuals? Or is it both?
I do a little of everything.
Okay. Wow. Well, this is wild. I mean, God, there's so much information. I think I understand it a little bit more. However, it's a lot. So is there anything you would like to add specifically about copyright or, Disney and copyright before we get going here?
I just feel like a lot of people get very caught up in the issue of, is this legal? And is this ethical? And they're not the same thing. There's a lot of things that are not necessarily illegal, but are unethical, like copying something that is in the public domain and saying that you wrote it. If you want to, try and do that with a Mark Twain novel, it's still plagiarism, even if it's in the public domain. But it's not illegal to take Pride and Prejudice and pass it off as your own, you're not violating any laws. You're violating a lot of ethics. On the flip side, there's a lot of things that may or may not be illegal from a copyright infringement perspective, but it's not unethical for a teacher to ask their students to draw a picture of their, favorite, a picture inspired by their favorite movie. And even if they're utilizing a character who's protected by copyright in what it is that they're drawing, they're doing it for educational purposes. They're doing it to share their creativity, and it probably falls into the ambit of fair use. But there are a lot of teachers and administrators and school boards, especially these days, that are worried that someone is going to come after them with a copyright infringement suit and their job is going to be at risk because they've allowed students to do something creative with things that they love. And a lot of that falls into the zone of fair use, which is where it should be. And I wish that there weren't so many people who were worried about that. And I wish that there was more clarity as to how fair use manifests on an educational level. There was a Ninth Circuit case literally 4 years ago, the week the pandemic started. There was a case involving songs from the movie Xanadu. A show choir out in California was utilizing the song Magic, which Olivia Newton-John so wonderfully does in the absolutely perfect movie Xanadu, and was sued by somebody who claimed to hold the copyright in the songs and the right to license it. They may possibly have been lying, but that wasn't really what the court was looking into here. The court was looking into whether or not the show choir's use of the song as part of a much longer, like a 17-minute production, and it was only a portion of the song, and it was used in a very different way, even though it was an extracurricular activity. Even those students who were participating either had to pay to participate or be sponsored, and that was found to be fair use. And it was found to be fair use whether it was being done in person or being done remotely and virtually. So there's clear case law for utilizing things, whether in classrooms or educational purposes or informational purposes like you and I are doing right now, like those posters behind you. You're not infringing on the copyright in any of those posters just because they happen to be behind you. But if somebody wants to make a major motion picture and films it where they know that some famous graffiti artist has done some art on a building and they don't credit or get the rights to use that piece of art, then they might be infringing on copyright. So there's different levels.
That's a whole other fascinating thing to me. Like when you do see logos and stuff, a Doritos bag or something in a commercial, to me, I'm always like, well, this could go one of two ways. This could be Doritos saying, you want to use our brand, you pay us to do that. Or it could be the movie saying, hey, this is great advertisement for you. You pay us for this advertisement. So that's like another thing, kind of a whole separate track. But
let me just go down that track for 10 seconds, 45 seconds. So you can utilize any brand name that you want to when you're writing something textual. So, for example, if Cory Doctorow wants to write Down and Out in the Magic Kingdom, he's allowed to do that. He doesn't have to get permission from Disney World to do so. If I want to mention America Online in a novel that I'm writing that's set in 1994, I'm allowed to do so. I don't have to get anybody's permission. If I want to be Grease 2 and have one of the characters ask another, have you ever read a Superman comic? I don't have to get permission for that. Those are all things that are allowed because of both the fair use doctrine for copyright and the fair use doctrine for trademark. However, if something's being used in an advertisement, then that is inherently commercial by its nature. And the artistic evaluation is much less. And this all goes back to a case from the 80s involving a movie called Fred and Ginger, which was about two dancers who their fans said, oh, they're like Fred and Ginger. And Ginger Rogers sued. And she lost because they were using her name and only her first name in a way that was not protected at that point in time by trademark law.
Just to go back to the Doritos example, if a bag of Doritos was seen on screen in a movie, does that become Doritos paying the movie or the movie paying Doritos?
Sometimes either way, but that's normally in a movie, you can do it without getting the permission, especially if it's not, foreground. But if it's in the ad for the movie, you need to be much more careful.
Interesting. That's fascinating. I'll leave you with this one last thing, because I've heard of, like, Andrew Lloyd Webber has sometimes made his musical School of Rock available, like, license-free to schools to put on their productions. It's just, the goodwill of education, right? What if there were a corporation out there, let's just say Disney, for example, was like, you know what? This character of Mickey Mouse, I think it would be awesome if people could do their own things with him. I don't want people to have to wait 95 years. We're going to say, go, have fun. Is there like a legal process to do that?
Yes. So it's very hard to put something in the public domain. It's very easy to say everybody can use this particular thing for any purpose they want to. But there's something very risky about doing that, because the minute you say you can use it for any purpose whatsoever, A, people will make porn. B, people will make commercial usage out of it in a way that you don't necessarily intend. This is why when people write fanfic or do fan art, I strongly have discouraged, and I need to disclaimer, everything I've said is not legal advice, including this. I strongly advise people not to say when they're posting fanfic or fan art on the internet or a fan film, I don't own anything, don't sue. Because the minute you say that, you are giving everybody a license to use your word for word words, which means they can take it, put it on Amazon, sell it for $9.99 or 99 cents as a Kindle, and they'll make the money, not you. And you don't have any control over what they're doing. If you write fanfic, if you do fan art, you own probably that content where it is not directly from the original source material. I don't recommend necessarily registering it with the Copyright Office unless you're doing something based on something in the public domain. And then you still need to say what the original source material is, because you're not claiming copyright in that. But you, if as a, fan creator, own the stuff that you are personally creating. And you want to be able to have control over that. The same way that, releasing something on Creative Commons, again, means that somebody else may do something with it that you don't necessarily want them to do.
All right, Heidi, thank you for the wealth of knowledge. Very much appreciated. Thank you for taking the time to come on the show. And yeah, that was a lot, but thank you so much.
Not a problem. Thank you so much for having me. It's been an interesting discussion.
Thanks for tuning into this episode. Don't miss any future episodes by subscribing and following Dizney with a Z, coast to coast on your favorite podcast app, where episodes are available 24/7. If you're a longtime listener of the show, thank you. And if you have the means, consider supporting the show over on Patreon. By joining Dizney Coast to Coast's Patreon membership, you'll gain access to extra bonuses, including live stream Ask Me Anythings, unreleased episodes, and more bonus content. Take a look at all that's available by clicking the Patreon link in this episode's description, and thank you for considering. Until next time, anything you need can be found in this episode's description, from additional information and links discussed in this episode found in the show notes, to the DCTC hotline where you can leave a voicemail and be heard on a future episode, contact info to reach me, access to the show's official website, some free gifts from me to you, and so much more. So be sure to check out this episode's description. Other than that, folks, have a magical day. Bye!